And now we are into chapter 7, which we're going to go over pretrial procedures and trial process. So now we're actually getting into the meat and potatoes of the court system. Remember, it's important to know how defendants are processed. So from the time they're arrested until they're convicted and sentenced. That's what we're looking for in terms of pretrial and trial practices. An arrest means taking an offender into custody. Usually they're made of criminal suspects by police officers, and the arrested person are referred to as arrestees. Remember, they're not defendants yet because they haven't been charged with anything. If subsequent developments provide officers with probable cause to believe that the suspect they have detained probably committed the alleged offense, the officer can arrest the suspects and take them to jail or in custody for further identification. Remember, probably committed, it's a probable cause standard. It is not beyond a reasonable doubt that they must be convicted with. Once they're there, they book them into the jail. So this is where they obtain background information, fingerprints, take their pictures. Then they're going to make an initial appearance in front of a judge and decide whether or not there's applicable charges. And this is where the DA will determine whether or not there are sufficient information to bring any action or charges against them. This usually happens within 72 hours of arresting them. They have the right to bail. Unreasonable searches and seizures or double jeopardy or compulsory self-incrimination are all parts of our Constitution, whether it be the Fourth Amendment, the Fifth Amendment, or the Sixth Amendment, and they have a right to trial by jury and a right to bail. Bail is just basically a surety, making sure that you'll return if you're released. Now, you can be placed on what's called your own recognizance, which basically means that you are stating that you will return. And if you have no prior offenses, most likely if it's a misdemeanor of some kind, they'll let you out and you wouldn't need a bail. Bail can be posted for criminal proceedings. You're going to a bail bondsman, which gives a written guarantee that you'll return, and money is put up for that particular instance. And again, we already talked about the bail bondsman or the bail company that can put up the bail, and usually there's a non-refundable 10% fee for that individual. And it goes through the Bail Reform Act. Then we get to what's called preliminary hearings. So in a preliminary hearing, you're going to have an initial appearance and a bail hearing. They're entitled after to a preliminary hearing. This basically shows what they've been arrested for and gives their initial appearance. And in a prelim, they determine whether or not there's sufficient probable cause to charge them with the crime. You can cover this with a grand jury indictment. We've talked about this before. Or we can do what's called an arraignment. So at the federal level and for California, arraignment is the official proceeding where defendants are informed of their formal charges and they enter a plea. So that could be not guilty, guilty, or what's called nolo contendere. Nolo contendere basically means that you'll accept the punishment, but you are not saying that you're guilty or innocent. If you plead guilty, it's the equivalent of a confession, and you can either enter obviously voluntarily or understand, and you must enter voluntarily and understand the charges against you, but it may be in combination with some kind of plea agreement that you plead guilty and take a lesser offense. Not guilty obviously means that there's going to be a trial date set and determine whether or not bail is necessary. And again, we already talked about the recognizance returning for the pretrial. Nolo contendere basically just means that you're not pleading to anything, but you're accepting the punishment. And then the Speedy Act of 1974 provides that once you are enter a plea of not guilty, there must be a trial within 70 days. Now, you can waive the right to a speedy trial, and oftentimes individuals do because that's a very short time period to get back on the clock or back on the calendar, and it doesn't give your attorney a lot of time to do their due diligence. Again, a jury trial versus a bench trial. We've talked about this in the last few hearings. Oftentimes you may choose a bench trial if it's a very technical case or a very emotional case that you feel the jury may be biased against the client. You may pick a judge or a bench trial. You have a right to a jury trial. Jury hears cases and decide guilt or innocence of the individual. Remember, you are only guaranteed a jury trial for felonies. Misdemeanors are not guaranteed a jury trial. And you can also have the jury do the sentencing as well and determine the punishment for the individual that's found guilty. The trial process is rare because most cases, as we said, over 90% plea out. But, some do get to trial, and this little diagram in your book shows you kind of the trial process. And we'll go more in depth in a little bit, but you're going to go into the indictment, the plea, opening statements, witnesses, closing statements, procedures from the judge to the jury, and then a verdict. Your opening arguments is where you can present your case. The prosecution is going to go first, followed by the defense. We always want to give the defense the last word because the prosecution has the burden to prove guilt. The prosecution then goes first. They're going to put on their case any witnesses, any theory. Oops, sorry, I went backwards. And then you're going to have a redirect. So the defense can then question all of the witnesses that were brought up by the prosecution. And they can do that in any manner they choose. Obviously, ask specific questions. They can negate evidence. They can impeach witnesses, which can be done in several different ways. You can prove they're unreliable, attack their credibility or their character, or if they're what we call a hostile witness, you can ask leading questions to determine whether or not they're there for the correct reasons. And we have different types of witnesses, obviously. So we have expert witnesses. They're going to bring something to the table, maybe ballistics or forensics, something like that. And then you're going to have your eyewitnesses or your character witnesses that are lay people that come and testify on behalf of the individual or against the individual. And there's also victim witnesses. So this could be someone that identified the individual that caused harm to them, whether it be, obviously in a murder, you're probably not going to have a witness be able to speak. But in attempted murder or carjacking or theft, you may have a witness testify or victim testify as a witness. Again, children can potentially be witnesses. However, it's not necessarily super reliable or beneficial for the child. It can be very traumatic. And that's why, over 95% of sexual abuse cases plea out so that the children don't have to testify against their attacker or their accuser. And then the procedure, you're going to go from the witnesses, the prosecution goes, the defense goes, and then at the conclusion, they may make a move for a directed verdict, which basically means if you took everything the prosecution said, it's still not enough to prove the case against them. It's very rare to get a motion approved on a directed verdict, but it is possible. And then the defense is going to put on all their evidence. The Fifth Amendment protects individuals from the right against self-incrimination. So you don't have to testify against yourself, but if you would like to, you're more than welcome to. And then the jury goes into deliberations. This can be hours, days, weeks, and they continue to move through the deliberation process. Must they agree on a verdict? Good question. Well, yes is the answer. They can use alternative jurors if one or more of the jurors become ill. But if they cannot determine guilt or acquittal, then it will be a hung jury. And then after the verdict, if the individual is found not guilty, there's no ability to retry the individual for that same crime. That would be double jeopardy. However, if they are found guilty, they are able to appeal that verdict. And that's it.